Okay, we are now recording. Okay, so let's talk about the quiz. Only one student turned in the quiz so far, so I don't know if you guys are working on it, but okay, what is a duty of care and what's your personal level of duty of care in your own words? Crystal, can you tell me what's a duty of care?
Duty of care means like someone have the responsibility to make sure the other person will not get hurt by your own negligence.
Sure. A responsibility that one person has, you know, towards another person, something like that. That's really all it is. What's your level of duty of care?
If I'm a housemate to another person, I will remember to lock the main door because I can foresee the
Okay, that's an example, and that's okay. You mentioned the word like, you know, foresee, like my level of responsibility is to maybe foresee things that could hurt someone else, something like that. You know, the actual answer would be ordinary care. That's the kind of the name of your duty of care. Like you guys all have a duty of ordinary care towards each other. Florian, hello. You guys all have a duty of care towards each other, and it's just a duty of ordinary care, kind of what you said, just a duty to make sure you don't hurt other people. Tiffany and Harry, okay. Okay, how about number 2? What does it mean to say the court in Donaghy v. Stevenson created a new kind of relationship? Aruni, can you tell me what new relationship they created?
I don't know.
我放不了歌了，等一下，
Sorry? Somebody
I
answer?
don't know.
等一下，
Yeah,
关
yeah.
了关了。好，
Isaac, what'd you say?
Nothing, sir. My bad.
Oh, okay. Harry, can you answer that? The court in Donaghy v. Stevenson, they created a new relationship. What is that new relationship that they created?
They created a new relationship between the manufacturer and the user of the product, not the customer.
Okay, so between a manufacturer and a user of the product. And what did they call this relationship?
I forgot the name, what they called it.
A neighbor.
Oh yeah.
Neighbor.
That's really all it is. It's just a neighbor relationship, and you find that through the neighbor test. Okay, when analyzing duty of care, and you know, if you guys have questions, either, you know, just unmute and ask me or raise your hand. If I don't call on you, just unmute and ask me. Maybe I didn't see you. When analyzing duty of care, what's the difference between foreseeability and just and reasonable? This is a super important question. Like I said, every single semester, students lose valuable points. Florian, yeah.
Foreseeability is objective, and the other one is no. Foreseeability is subjective, and the other one is objective. In the society, we ask if.
Okay. Let's see. Nicola, can you expand on that? Tell us a little more. You can't just give us one word. What do these tests mean? What's the difference?
Okay, so foreseeability is something personal. So it's like, can I see that I have responsibility over someone or of the matters, right? And the second one, the objective, is related to society, as Florian said. So it's like, does the society believe that I have this responsibility, you know?
Good. And that's just right. So foreseeability asks whether an individual can see that he or she has a personal responsibility. And sometimes the answer is no. A bus driver may not think they do. Ask a bus driver in China if they think they're responsible for every single person. They might say, no, I don't think so. Ask a cook if they think they're responsible for every person. They might say no. That's foreseeability. So we also have just and reasonable, which asks whether society believes this individual should be responsible. Maybe as a teacher, I think I'm not responsible for these guys. They're in university. But in society, do we want a university teacher to be responsible? Okay. Next, Joaquin hates the government and the status quo. He dresses up as a clown, goes on television, tells everybody there should be chaos and anarchy. He's not really serious, but people take his message seriously and they go out and start causing damage. Who are Joaquin's neighbors? Anybody see the movie Joker? Who are the Joker's neighbors? Junpyo.
In this case, I'm not sure.
Juan, what do you think?
Hello, sir. Would it be the persons that create chaos because of him?
Okay, so what did this guy Joaquin do?
He created, like, he incentivized the idea of chaos because he didn't.
He said chaos is good.
Yep.
When he said that, who should he have seen? Who should he have foreseen might be affected? Was he just standing on the street saying this? Was he running through the streets saying this? Where was he saying this?
He was on television, right?
So, who could he see might be affected by his message?
Society.
Audience.
Well,
Television audience.
anybody watching television, right? Anybody watching this television program. That's who his neighbors are. Now, what about if somebody's watching this television program and then he says there should be anarchy, there should be chaos, and this person runs outside and just starts hitting people? Should Joaquin see, in your opinion, Juan, should Joaquin see that if I create chaos, other people will be hurt?
Yeah, of course.
So maybe anybody watching this television program and anyone who is injured by someone who was watching the television program, right? So a lot of people, not everybody in society, but a lot of people maybe. They are his neighbors. He should have seen. Now, what are the two key words for the neighbor test? Anybody? 2 words.
Direct affected.
Directly affected.
Thank you. Direct effect. So the question is, who was directly affected by Joaquin? Anybody watching the TV show was directly affected, and anybody who was hurt by them was directly affected. And of course, we could use the but-for test, and we could go and continue this chain, and then anybody in the world might be affected, but we also have the foreseeability test. Let's go on. The recording artist, Marshall Mathers, also known as Eminem or Slim Shady, made a song about one of his fans, Stan, putting his girlfriend in the trunk of a car while drinking a fifth of vodka and driving off a bridge. If someone actually did this and the family of the deceased woman sued Eminem, how might the court discuss Eminem's duty of care to Stan and to Stan's girlfriend? Tiffany, can you tell us your answer?
There's the freedom for free speech, and in this case, there's no foreseeability that nor proximity between Stan and Eminem. I think it's more like slander, rather. If it's a better case for argument here, it will be for slander. Or on the other hand, there's the freedom of speech. There's just no way that.
Let me take a step back because you're jumping into some other things. You said there's no proximity. I agree. So proximity is 2 kinds, right? Physical and legal. Physically, Marshall Mathers doesn't know this person, Stan. They're not in the same place. And legally, they have no relationship. So there's no proximity. The next test is foreseeable. So Tiffany, could a musician see? if he writes a song that's very specific, and then could he see that someone might do that?
I think so, but at the same time, there's so many people.
But maybe, maybe. He said, I'm Eminem and you should do this. And lots of people love Eminem. And the question is, do recording artists have a responsibility to society? And maybe they do. So it is a maybe. Let's just go through the test.
Eminem is not stylistically someone who sells music to people to make them feel like they have to do something for him.
Doesn't matter. He is an influential person. Well, let's just go through the tests. Then let's discuss those other elements. Just Unreasonable. Tiffany, in your opinion, do we want in society artists who are influential to have a responsibility about what they tell people to do in their art?
Yes, that responsibility doesn't have an authority to it.
Not my question, though. My question is, in society, do you think we want artists to have a responsibility?
It's just, but it's not reasonable.
Maybe. Caitlin, what do you think about that question? Do you think artists should have a legal responsibility for the message that they put in their art?
Yes, I think so, because it's their, what they make, it's like their own opinion or their view, it's their ideas and their imagination. So what they do is their creativity and it's their own work, so.
So if I made a piece of art, like a song, that said, you should kill your parents, and I am a very, very famous artist, and I make a song called Kill Your Parents, and then you go and kill your parents, do I have any responsibility for that? I made a song recommending that people kill their parents.
I think so, because who else would you blame? You can't blame just, oh, this kid this person randomly thought it, because a lot of people, like if you're a young person, you're impressionable, and this artist might be very influential, and I think so.
Okay. And Tiffany, what's your response to that? Because I know you don't agree with that point.
Because you're buying an entertainment. It's not something essential to society. You're not an announcer to some government enterprise. Maybe like the Speaker of the House would be responsible.
Okay. And so, Caitlin, what's your response to that? Kids don't have to go buy this album.
Wow. Oh, no, that's right. Kids don't have to, but I just think kids, like, you see a lot of cases, like a long time ago, where a lot of kids were held accountable for like their own mistakes and they were sent to jail, but now you have juvie. So yeah, maybe the guy shouldn't, it's horrible that he's like gone and killed people, but like, if you look at certain countries, they allow kids to just walk around, with guns or like with weapons, and they're allowed to walk into schools like that.
Let's stick with artists just for the moment, because we can get into a lot of different discussions here. There's no right answer for this. Eminem was sued many times by many people about his music. Generally, he has freedom of speech, as Tiffany said, and therefore he's protected because he's creating an artistic product, and he is not a representative of anything. He's just creating art, and therefore nobody should take art to be fact, right? Just because there's a book or a song or a painting or whatever that says you should do something doesn't mean you have to do it. But it is an interesting discussion. And then neighbor, who is Eminem's neighbor? You could argue it's anybody who heard the song. Do you think society should have a duty of rescue? You can answer that on your own. In Bolton v. Stone, obiter dicta is anything in a court case that the judge says that isn't the law. Anything else is obiter dicta. Even the most careful person cannot avoid creating risks. So if this is true, why does the court allow people to sue each other for accidents? What do you think, Isaac? No? No, Isaac? Isaac? Am I saying it wrong? Okay. What do you think, Juan?
Wait. I think I agree with this statement. Like, you know, like everything creates risk. It's not like.
So why are we allowed to sue each other?
Because, well, maybe it's not an accident. Maybe you're creating a risk, but it's been, well, how do you say that?
No, but I'm talking about accidents. I said accidents.
Oh, I don't know, sir.
Anybody? Why do you think we're allowed to sue each other for accidents?
I think it's related.
Nicola?
Oh, George. I think it's because sometimes the accident happened because who provokes it was careless.
Okay, so I think that's a reasonable answer. Just because something was an accident doesn't mean I was careful enough. If I have a nursery school and you bring your children to my school and then I'm not paying attention to them and they run into the street and get hit by a car, I can say, oh my God, it's an accident. And it was an accident, but I'm the one who was careless. I certainly didn't do it on purpose, but that doesn't mean I have no responsibility. Okay, 8, reasonable person, you can look that up yourself. Difference between 9 and 10. So 9, I give you too much work and it stresses you out and you don't study and you fail. What if I really give you much too much work? If I give you so much work that you just can't do it, you get so stressed out, you give up and you fail. What do you think, Jody? In that case, is my duty of care foreseeable?
In my opinion, there is no duty of care foreseeable. Like,
why?
Based on the definition, here the defendant does not indirectly know about the student's situation, and they also don't complain while in the class.
So, okay, but okay, anybody disagree? Anybody
I have a question. I have a question about it. Like, if, for example, we have 20 people in the class, and if everybody's fail, or if just one guy or lady fail, I think it's different. I mean, can we interpret it's different?
What if everybody fails?
Yeah, this is the point.
If everybody fails, then I should have seen that it was too much work.
Okay.
If only one person fails and everybody else passes, no, that's more like number 10. I give you too much work, but one person had an unexpected situation and they failed. Then they can't sue me because it's just them. Okay, any questions about the quiz? No? Okay, good. For homework this week, I asked you guys to look at what Vosberg v. Putney, Martin v. Herzog, Grayson v. Irvmar, those cases. We'll get to those today. But before we do, let's talk a little about your midterm. So I had said last week that for the quiz from now on, you can either send me the quiz or send me a part of your coursework. Last week, we talked about tasks B and C, right? We talked about the second and third part. Task B was tell me about negligence and give me cases. Just the law of negligence. Do not talk about the people. Don't talk about Bobby or any of these other people. Just talk about the law. What are the rules for negligence with case references? And that's task B. Task C is the exact same thing. Go through, you know, duty of care, test 1, duty of care, test 2, duty of care, test 3, duty of care, test 4. Then breach, test 1, breach, test 2, breach, test 3, breach, test 4, damages, test 1, damages, test 2, damages, test 3. Understand this. Beautiful writing in law is clear. It has nothing to do with big words. It has nothing to do with dictionaries and thesaurus and having lots of beautiful grammar. Nothing to do with that. It's all about, could a 16-year-old or a 15-year-old read your paper and understand it? Could they follow? So in law, we'll have a lot of sentences like, the first test for duty of care is proximity. Proximity means what? The second test for duty of care is foreseeable. Foreseeable means what? The third test for duty of care is just and reasonable. That's good writing in the law. That's not boring. That's clear. So be aware that what I consider to be good writing is simply how clear is your writing. If I get lost reading it because there's so much grammar, then it's not good. I just want to be able to follow it. So simple language, short sentences, simple words. You don't get more points for using better English. You get more points for it being super easy to read. Is that clear? Okay. So task B is just the law. Task C is just the facts. Let's look at task A.
Wait, sir, sorry, I have a question.
Yes.
You said we could give you task B and task C for you to look at. Where do we hand that in?
In the quiz tab, instead of uploading the week 3 quiz, just upload your task A or your task B or your task C or something.
Okay.
I didn't make a separate tab for it, just put it in the quiz tab. I will say, the only thing I'll say is, you know, there's a bunch of people in this class and I can't read, 10 pages from each student each week. It's going to be too much for me. So when you send me things, make it clear what you want me to read. I can read like a page or two from each student. If you want to send me a long thing, put the stuff that's new or the stuff you want me to read in highlight, in yellow or something. Just make it clear what you want me to read. Don't just send me 6 pages of text and say, teacher, read this. Ask me specifically, like, is this part okay? Or is the duty of care part okay? Or just, try to give me some help, or else I'm not going to be able to read everybody's. Okay, so jumping forward, let's make sure we understood task B, what we did last week. So task B, follow this PPT. I'm telling you, don't deviate. Don't just do your own thing. Sometimes students do. Now, you want to give me more? Fine. Don't give me less. So start with an explanation of negligence. What is a tort? What is negligence? Give me some definitions with references. Then duty of care. The first test is, the second test is, the third test is, the fourth test is, with references, case references, right? Not journals, case references. How do I highlight? Where'd my highlighter go? Hey, where's my highlighter? That's weird. Okay. Did I lose it? Okay, anyway, I can't even write on this. So duty of care, the 4 tests, breach, the 4 tests, damages, the 3 tests. That's task B. Task C, exactly the same thing. The first test, the second test, the third test, the 4th test. But in task C, you're going to talk about these people, the people in our story. So in our story, we have this guy, Bobby. He owns the restaurant. Don't talk about him yet. You're going to really be talking about this person, Jack. And yeah, I don't like this. It's making me unhappy. You'll be talking about this person, Jack, and you'll be talking about this person, Ashley. That's task C, right? So in task C, The first test for duty of care is proximity. Proximity has two parts. Were Ashley and Jack in the same place? Explain. Never just say yes. Never just say yes or no. Always tell me your logic. Yes, they were in the same place because they were both in what. Or no, I don't think they were in the same place because what. Second test of duty of care is foreseeability. Should Ashley have seen that she has a responsibility to be careful? Yes, because she what, or no, because. You have to give me the because. Okay? So just follow the tests for task C. Duty of care, 1, 2, 3, 4. Breach, 1, 2, 3, 4. Damages, 1, 2, 3. Now, let's go back to task A. Task A is a little different. So for task A, here we are. Figured it out. I'm a genius. Okay, the rules involving the incorporation of an exclusion clause. So here's what we have to know. We have to know what is an exclusion clause. We have to know what does by notice mean. We have to know what are limitations. We have to know what is incorporation. So we got a couple of things we need to know here. So first, we have to understand what these words mean. Then we have to understand the rules, the limitations. Then we need to talk about in our case. So first of all, what does incorporation mean? Well, the meaning that you're probably familiar with is when we talk about companies, like a company was incorporated. But that's the new meaning of the word. The word incorporation in English has an older meaning, which means to put in. So for example, I could say, I have incorporated multiple choice questions onto your final. I have incorporated videos into my class. Incorporate just means to put something in. So when we say incorporation, that's a legal word. It just means we're putting something in. What are we putting in? So we're putting something into a contract. And what we're putting in is an exclusion clause, by notice. Clause is a sentence in a contract. That's what clause means. Clause just means a sentence. An exclusion clause is a sentence that excludes. It's a sentence that says, I'm not responsible. Now, you're going to see these things everywhere once you start looking for them. You see them in a gym, in a hotel, in a hospital, in a restaurant. Everywhere you go, you're going to see a sign. And the sign says, essentially, we're not responsible. So go to a gym. You might have to sign a form. What does that form say? We're not responsible if you get hurt. Go to a hospital. You have to sign a form. What does it say? We're not responsible if you get hurt. Go to a swimming pool. Go to a restaurant. Go anywhere. Go to a hotel. Now, sometimes you have to sign your name. That's called by writing. So at a doctor's office or at a gym, they actually give you a contract and you sign your name. That's an exclusion clause by writing. A lot of places don't have that. Like if you go to a hotel will have a sign usually at the front desk. So there might be a sign on the wall behind them, and the sign says, if you lose your things, we're not responsible. That's an exclusion clause by notice. So by notice means to put this exclusion clause on a sign. That's what it means. It could be a sign on the wall, it could be a sign on the cash register, but it just is a sign that says, if something happens, we're not responsible. Now, there are limitations to this. So let's move forward and see the limitations. So first, what is an exclusion clause? I want this in your essay. What is an exclusion clause, right? It's a sentence that says I'm not responsible for something with a reference. I want references for all of these. Incorporation, you don't really need to explain that. By notice, you do have to explain that it means not by writing, but by putting up a sign. Now, what if I go to a restaurant? Let's say, Crystal, you come to my restaurant and I say, oh, Crystal, welcome to my restaurant. We just wanted to let you know that if you lose your jacket or your bag, we're not responsible. So please take care of your jacket and bag. Is that an exclusion clause?
No, unless it it has been incorporated in the contract? Or
It is in the contract. Contracts don't have to be written. There are only a few kinds of contracts that have to be written. Some of them do. We'll talk about that when we get to contracts. Contracts that are for a certain amount of money, for example, have to be written. But most contracts don't have to be written. So yes, if I said that to you, that's an exclusion clause. Is it by notice? No, it's not on a sign. It's verbal. There are three kinds of exclusion clause: by writing, verbal, or by notice. So maybe I asked you to sign your name, that's by writing. Maybe I put it on a sign on the wall, that's by notice. Or maybe I just told you, that's verbal. All three are exclusion clauses. Yes, Florian.
When we speak, if you forget or someone wasn't present to testify, how do you prove that you actually told me? Or
Evidence is always an issue, and you're right, I would need evidence, but probably if we were at the front desk, let's say you come to my restaurant, and I say, welcome to the restaurant, you know, we'd like to tell you our rule is please keep your jacket and bag with you. There are a lot of thieves around, and so if I say that, and then Crystal sues me, she says, David, I don't remember you saying that. What am I going to do? I'm going to bring in Caitlin, who's one of the waitresses, Jody, who's one of the waiters, Florian, who works there also. I'm just going to bring in people who say, yeah, David always says it to everybody, and I heard him say it to Crystal. That's the best I can do. Yeah.
The same question applies for verbal contract.
Yes, exactly. If you don't have a video or an audio recording, you would get evidence of people who were around, who heard you make the contract or saw something happen. Now, if you can't get that, then you would try to get what's called a character witness, which I think I mentioned before, which is someone to testify that David is an honest person and Crystal is not. If I can have some people come to court, like Crystal's old boss or Crystal's ex-boyfriend who says, oh my God, all she does is lie. She is a liar. Don't believe what Crystal says. And then I have a bunch of people who say David is an honest person. Well, the jury might believe me. So, but yes, evidence is always an issue. A lot of the reason that things are written is because of evidence. Limitation, you know, I want the definition in English, but obviously it's something that limits, something that restricts. Why do we need to restrict? Well, let's talk about the rules. How do we know if these sentences are okay? We have two rules to find out if these sentences are okay. So number one, was the exclusion clause incorporated? And here's the key part, when the contract was formed. So let's say, for example, Crystal comes to my restaurant. Okay, and you come to my restaurant and we say, welcome to the restaurant. And you put your, we say, hey, just, put your stuff down and feel free. We have a beautiful bathroom. Feel free to go, wash your hands, relax, and then come back. You can go listen to the music. We have a live band, and come back and your food will be ready. So, okay, you put your things down at the table. You go, we'll do whatever. You come back, your stuff is stolen. And you come to me, the manager, and you say, my stuff was stolen. And I say, oh, I'm sorry. We have a rule that if you leave the table, we're not responsible for your stuff. Is it okay for me to tell you the rule after you made the decision to leave your stuff at the table? Or did I need to tell you before?
You have to tell me before I order the food, because this is where I accept your service.
Sure, because maybe you might choose to leave. What if I said, so the key question here is, when is a contract formed? Let's continue with this example. Jody, let's say that I walk into a restaurant. Okay, I open the door. Do I have a contract with the restaurant right now? I'm a customer. I just opened the door. Jody, do I have a contract with the restaurant?
Yes.
Yes? To do what? I just opened the door. What kind of contract? What do I have to do? You can't open the door to a restaurant. Now you have to pay them.
But it's not your place. That's restaurant place. I mean, like, if you come to a restaurant, that you need to be responsible for.
Wait,
anything.
Jody, I don't think you're understanding. You have a restaurant, okay? It's called Jody's Restaurant. And I come to your restaurant tonight and I just open the front door to look in. Do I have to pay you money?
No.
No, of course not. I just opened the door. I don't have a contract with you. So, okay, I walk into your restaurant and I say, hi, Jody, can I see a menu? You say, sure. Do I have a contract with you right now? Do I have to pay you for something?
Not yet.
No, I didn't order anything yet. I sit down at a table and I say, okay, can I please have a hamburger? And you say, okay. Now, do I have to pay you?
Yes.
Yes. A contract is formed when I make a promise to you and you make a promise to me. I'm promising that I'll pay you and you're promising that you'll give me a hamburger. At that moment, we have a contract. Now, another way to say this is the offer. You have offered me a hamburger and I have accepted. At the moment that there's an offer and an acceptance, we have a contract. Now, what if my hamburgers usually get people sick? Or sorry, your hamburgers. Do you need to tell me that before I order? If the meat is dangerous today, you can lie to me and I can get sick and that's okay?
No, that's not okay.
It's not okay. If you know that the meat isn't safe, for example, you need to tell me. Right? You have to tell me before.
Yes, of course.
Right, of course. Right? You have to tell me whatever the exclusion is before we form the contract. That's the first rule. Now let's look at some of the cases that I gave you. Right? Incorporation when the contract was made. How do we know when a contract is made? It's when there's offer and acceptance. And I had asked you, I think for homework on the first week, to look at these two cases, if I remember right. Can anybody tell me what happened in Ali v. Marlborough Court Limited?
Nicola.
Yeah.
In the first case, the plaintiff went to her room and leave the luggage. When she went out to the hotel, when she came back, her luggage was stolen. So she went to the front desk and complained about the luggage stolen. And they said in the wall, inside of the room, there is a notice that explained that they have no responsibility of the luggage inside of the room if there's no one inside. And the question was like, yes, there is this notice, but when she make the contract, when she did the check-in, she didn't know. The notice is inside of the room, so she cannot know this notice.
Good.
And then, right?
It's a good explanation. Okay, so Miss Ali, staying at a hotel, she has a very expensive coat. She puts it on her bed, she goes out, locks her door, goes out. Comes back, coat's gone. There is a sign. The sign is in the bedroom on the back of the door. And this is what the sign says. The proprietors will not hold themselves responsible for articles lost or stolen. Is this okay? Did she have a chance to know this rule before she decided to stay at this hotel? No. When was the contract made? Right? The contract was formed when she paid for the room and she got the key. That's when the contract was made, when money was exchanged. At that moment, offer and acceptance, did she know about this rule? No. And therefore, the rule, this sign, has no legal effect. Is the hotel responsible for her fur coat? Juan, is the hotel responsible for her fur coat?
Well, if she was not aware, they didn't tell him, like they didn't, you know, tell her, or she didn't write her name or anything, then she is responsible.
Correct. So the hotel is responsible because this sign was not at the place where she formed the contract. Where did she form the contract, Juan?
At the desk when she paid for the room.
And so what they needed is they needed to either tell her then, or have her sign something then, or have a sign on the wall. Those were their choices. They didn't do those things. You're going to see this all the time in hotels, that there's a sign in the room that says, we're not responsible. Those signs have no meaning. If you lose something, they are responsible. Okay, now I expect you to use this case in your essay. Okay, use this case. Also use other cases, but use this one. It's an important case. Next, same idea. Thornton v. Shoelane. So you have this guy, Mr. Thornton, and he's driving his car. Anybody remember this case? Caitlin, you say yes. Can you tell us about it?
The case is this guy, he has a performance. He plays like an instrument. I forgot. He was like in a band. And
Plays
he has
trumpet.
for that night. So he goes to Shoe Lane, which is like a road, and he goes to this parking lot and gets a ticket. There's like a sign next to him that he sees, but he doesn't like read it thoroughly. Then he goes to his performance, and then when he comes back to his car, he gets injured, and he tries to sue, but the sign said like, we're not like responsible for any injuries you may receive in this parking lot or something like that.
Good. Good. That's pretty clear. So yeah, he was a musician. He parked his car at this parking lot, and there was a sign. Now, what did that sign say? It said this: this ticket is issued subject to the conditions of issue as displayed on the premises. What does that mean, right? That's not clear at all. And that's what he said. But actually, what does it mean? It means that there are signs inside the parking lot, and you have to follow those signs. That's what it means. This ticket is subject to the conditions displayed on the premise. That's what they mean, but it's very legal language. So he goes in, and there is a sign in the parking lot. The sign says, we are not responsible for any injury to the customer, howsoever that loss, misdelivery, damage, or injury shall be caused. He slips on a hole in the ground, and the facts are he was a little bit drunk. But is this a good exclusion clause? Well, Ploy, tell us, when did he make the contract? Ploy? Ploy, can you hear me? Can you hear us?
Yes.
Ploy? No? Yes? Can you hear us?
Hello? Hello?
Yeah, hi. Can you hear us?
Yes, but the internet connection is not so good. It lags a little bit.
Okay. Did you listen to my question?
It lags, so I didn't get the question fully. Can you repeat?
Okay. I just wanted to know, well, now I've even forgot my question. Okay. So I just want to know, when was this contract made? That was my question. Floyd, when was this contract made? Where was the contract formed?
Just a second. I remember it. Just a moment.
Caitlin, when was this contract formed?
It wasn't formed because
There is a contract. What was the moment of offer and acceptance?
Well, when he took the parking ticket?
Correct. So at that moment, when he took the ticket from the machine, did he know that this place is not responsible for any injury? No, he didn't know that. That was on a sign inside, and that's not fair. You can't make a rule after someone makes a contract. That's totally unfair. You know, that's like me saying, okay, Ploy, I'm going to rent you my bicycle. Okay? Floyd, you hear me? I'm going to rent you my bicycle for 100 RMB a day. Cool? So you take my bicycle, you give me 100 RMB, you come back tomorrow and the bicycle's dirty. And I say, oh, Ploy, I never told you. Actually, there's a clause that says if it's dirty, you have to pay me 1,000. Is that okay?
No, it's not acceptable because you didn't state it before.
Right. And had you known that before, you probably would not have rented my bicycle.
Sir, I have a question.
Yes.
So what if, I don't know, the lady that gave the ticket to the guy for the parking lot said,
Wait, let's be clear. There was no lady, it was a machine.
Okay, then no.
That's why there was nobody to talk to.
Okay.
Now there's another problem here though, which we'll get to in a minute, but there's another problem here. And that has to do with something called automatically invalid clauses. Let's say that one, you are sick and you come to my hospital. Okay, I have a little clinic, and you come to and you just got hit by a car. Okay, and so your arm is broken, you're in a lot of pain, and you come in. I say, Juan, welcome to my clinic, and there's a big sign on the wall, and the sign on the wall says, if the doctor is careless and kills you, it's not the doctor's fault. Is that okay?
Well, I guess it is, because like they are clearly showing you that.
Right. I mean, I'm telling you when you made the contract. I'm telling you the exclusion clause.
Yeah.
Well, let's talk about the second rule, reasonable notification. And what does that mean? So the first rule is when the contract was formed, did the customer already know about this exclusion? The second is, was the exclusion in a reasonable place? So I'll give you an example. I once went to a restaurant in China and I asked them, do you have an exclusion clause? And they said yes. And the guy literally, I'm serious, took a painting off of the wall and behind the painting was the sign. Is that legitimate? Is that a reasonable place for the sign? No, of course not. Just because you have a sign isn't enough. It has to be in a reasonable place. That's the second rule. So let's talk about that rule. Then we'll come back to my example with one. Reasonable notification. Okay, and here's the sort of legal language. Was the exclusion clause brought to the party's attention in a manner that the party would expect? Would I expect an exclusion clause to be under a painting? No. So that's not reasonable. You know, you have to be shown the exclusion clause. Like what if, Florian, you come to my restaurant and I say, hey, welcome to my restaurant. I shake your hand. And then you sit down and you get your thing stolen. And I say, oh man, look, it's tattooed on my hand, the exclusion clause. You should have read my hand when I gave you a high five. No, of course not. You didn't expect the exclusion clause to be on my hand. It has to be in a place you would expect. Let's look at two cases that talk about this rule. So Chapelton v. Barry. Anybody remember this case? Anybody remember? No? Maybe I didn't ask you to look at this one.
It's in the beach.
It is in the beach. That's true. Tell me a little more about the beach.
Chapelton hired a chair or something.
Yeah, he rented a chair.
He rented a chair, and there's a sign in the ticket as well.
Okay, so let me explain. So he goes to the beach, and there's a big pile of chairs with a sign on top. There is a sign, and the sign says this, $2 for 3 hours. That's it. So he takes a chair, he puts it on the beach, and then he goes to pay for it. So he goes to another desk, he gives them $2, and they give him a receipt, just a little piece of paper. Okay, he puts that in his pocket. He sits down in the chair, and he gets very badly cut. The chair breaks, and it's a metal chair, and it cuts his arms all up, really bad cut. So it's serious. He goes to the hospital and of course, you know, has to pay the doctor, whatever. And then he sues this beach. Barry UDC is the name of the municipal township or the city that owns the beach. And of course they say, listen, it's not our fault. On that ticket, It says the council will not be liable for any accident or damage arising from the hire or of the chair. So here's the two questions. First of all, when was the contract made? Aruni, when was this contract made?
It was obviously before he rented the chair.
Wait, tell me, Aruni.
When he got the ticket?
Anybody disagree? What happened before he got the ticket, Aruni? When did he promise to pay money? Just like when I ordered a hamburger from Jody. At what
As soon as
moment?
he rented the chair, as soon as he rented the chair, he was offering to pay money. So
okay, so he saw a sign that said $2 for 3 hours, and then he picked up a chair. That's the same thing as if I go to Jody's restaurant and I see a menu that says hamburger $10, and I say, please give me a hamburger, right? Aruni, does that make sense?
Yes.
It's the same logic. So he knew how much money it was. Of course, he didn't take the money out of his pocket at that moment, but just like at a restaurant, I didn't take my money out of my pocket when I said, please give me a hamburger, but I knew what I was getting into. So that's the moment the contract was made. Did he know this exclusion clause at that moment?
No.
No, he didn't. So that's the first test. Remember, the first test is, did he know it when the contract was made? The second test is it in a reasonable place? So Aruni, in this situation, he rented this chair, and then he gave them the money, and they gave him this little piece of paper, a receipt. Is it reasonable for him to expect that on the back of this receipt would be important information he needed to know?
No.
Not really, right? You go to places all the time and you get a receipt. Does someone disagree with that? Isaac?
I disagree.
Wait, what? Was that Isaac who said you disagree?
Yeah, it was me.
Okay, Isaac, your camera's off, by the way. Unless you have a good reason, turn your camera on. Put on some clothes and turn your camera on.
Hold up. Here we go.
Great. Why do you disagree?
I mean, because a lot of times, there are a lot of, I don't know how to explain. Like a lot of contracts, you don't read a lot of it, but there's a lot of information on the back that if you
sure, but this wasn't a contract.
You pay more attention, right?
If you let me change the example. Imagine you go to a little store, like in China, one of those like Kedi convenience stores to buy like a steamed stuffed bun. You know what I'm talking about? Those little stores.
Yeah.
Okay. You go in, you give them whatever your 10 kwai, and they give you this little, it's like a Lawson's. They give you a receipt. You eat it and you get sick. Now, actually, on the back of the receipt, it says, we are not responsible if you get sick from eating the steamed stuffed buns.
Right, exactly. They warned you, right?
How many times in your life so far have you carefully read the back of a Lawson's receipt?
Not once.
Right.
But
because nobody expects that that's where it'll be. Look, if you look at a contract, you're right. Contracts do have a lot of little writing on the back, and people expect that. You've never looked at the back of a Lawson's receipt.
Well, that's what I'm saying, because like companies, they'll pay attention to that, so that's why they'll put it on the back. So they won't expect the customer to look at it, but they'll still put it there.
That's the point. That's illegal. That's exactly the point. That's illegal. If that happens to you, that thing on the back of the receipt means nothing. It doesn't protect the company. That's the point of this court case. Okay, there's an exclusion clause here. So at first they held for the district council, the Court of Appeals upheld, the House of Lords agreed, they held for Chapelton, they said, the contract was created when he took the chair from the pile, the ticket was just a receipt, and you can't just put things on the back of a receipt. Now, to answer more, Isaac or Isaac?
Isaac.
Oh, okay. To answer more Isaac's point, let's look at the second case, Parker. So Parker, he went to a railway station. He went to a train station, and he left his bag at a baggage check. You leave your bag there for a couple of hours. And they gave him a ticket. And on the back of the ticket, it said they're not responsible for items that get lost. The bag got lost, he sued them. They said the back of the ticket had this. Now, Isaac, do you think that if you give your bag to a place to hold it and they give you a ticket, there might be important information on the back of it? Should you read it?
I mean, not really.
That was the question in this case. So the railroad company, of course, they said, oh yeah, that's normal. They should read it. The customers should read it. And Mr. Parker said, but nobody reads that. So the trial court, they found for Mr. Parker. They said, nobody reads it. It's reasonable. Nobody reads it. They ordered a new trial, and at the new trial, they just said, here's the deal. It's not Mr. Parker's fault, because nobody reads the back of a ticket or the back of a receipt. But if at Lawson's or at a train station, they give you the ticket and say, please read the back. Now, sometimes when you get a ticket these days, they will say that because of these cases. They'll say, please read the back of the ticket. If they say that, now the things on the back of the ticket are part of the contract because you got it when you made the contract. As long as there's reasonable notice, as long as they told you. So let's go
Sir
back.
David?
Yes.
Yeah,
Yes.
I remember a case about Liable and McDonald's,
Yes.
the hot coffee, and then the McDonald's spilled it into her legs, I think, and then she sued the
McDonald's
McDonald's.
didn't spill it on her.
I don't know.
She bought it and was driving and she spilled it.
And then she sued the McDonald's and she won, right?
Correct.
It's just because of hot coffee, and the McDonald's didn't tell about it.
Well, look, everybody knows that hot coffee is hot. Nobody needs to say hot coffee is hot. Although lots of times you do see on the cup now, it says caution, hot coffee, things like that. It's not that the coffee was hot. That wasn't the problem. It was that the coffee was boiling hot. Nobody serves coffee boiling hot. Nobody serves that. If you go to any restaurant in the world, they will pour you a cup of coffee that you can drink, right? Nobody pours you boiling hot coffee. That's crazy. You know, so they gave her boiling hot coffee. So on the one hand, that's crazy. But then on the other hand, this had happened like 20 times. McDonald's kept giving people boiling hot coffee and they kept getting burned. If the court didn't allow this woman to win, McDonald's would keep doing it forever. And we don't want a big company to just have so much money they can burn people.
Okay.
There's a case right now where people are very angry at, who's the guy who runs Amazon? What's his name?
Jeff Bezos.
Sorry?
Jeff Bezos.
Yeah, Jeff Bezos.
Jeff Bezos.
So what happened is he was remodeling his house and he got $16,000 worth of parking tickets. He has so much money that he would get a parking ticket and just not move his car. He didn't care because it was just better for him to just keep getting the tickets. Now, the only reason that can happen is we're not talking about him physically hurting people. But Jeff Bezos has enough money to go out and hurt someone and just pay them, hurt someone, pay them, hurt someone, pay them. He could. And so the court has to stop that. So they'll give him an injunction. Now, I'd like to get back to the example with Juan. Juan, you got hit by a car, your arm is broken, you come into my doctor's office and there's a big sign on the wall. And the sign says, if I am careless and I kill you, it's not my fault. Now we have a problem, right? Look at our two rules. Number one, did Juan know about this rule, this exclusion clause when he made the contract? Yes. right? You don't have to come here. You can go somewhere else. You know my rule. And number two, this sentence, this exclusion clause, is it in a reasonable place? Yeah, big letters on the wall. But how could this possibly be okay? For me to say, if I kill you, it's not my fault. It just can't be okay, right? It just seems wrong. And the court says it is wrong. Because according to this law, the UCTA 1977, the court is going to look at exclusion clauses to make sure, even if rule number 1 is okay and rule number 2 is okay, is it reasonable? So when I say limitations, what I mean is this question: is it reasonable? Even though rule number 1 is okay and rule number 2 is okay, sometimes an exclusion clause isn't reasonable. So let's talk about when is an exclusion clause not reasonable. Now, my example with Juan, obviously that's not reasonable. Why? Juan, why is that not reasonable?
Because it simply is, well, it's not reasonable because, I don't know, like it is threatening your life, like it's being negligent.
So I'm saying if I'm negligent, you can't sue me.
Yeah.
Right, that's not reasonable. Now, what if you just got hit by a car, your arm is broken, you're in so much pain? Can I just say, yeah, just go to a different doctor? What if you're about to die? Can you just go to a different doctor?
Well, I guess not. Like, they should treat you right away, right? Like, it's not...
If you come into my office and you're about to die and you see the sign on the wall, do you care?
Of course not.
Of course not, right? That's an example where our bargaining position is not equal. You have no bargaining power. I have all of the bargaining power. I could say anything and you'll say yes. If you're about to die, I could say, you know, you have to give me your house. You'd say yes. You'd say yes to anything. You're about to die. In that case, if one party has all the power and one party has no power, these clauses don't mean anything. Now, what about an inducement? An inducement is like a gift. Let's say that I say to Ploy, today my salon, my hair salon, has a special deal. For 1 RMB, we will color your hair any color you want. And you say, oh my God, 1 RMB, that's obviously a great price. So you come in and there's a sign on the wall that says, no matter what happens, we're not responsible. Now that seems a little crazy, but you think, hey, 1 RMB. So you pay 1 RMB, we put this stuff on your head and it burns you and it's the bad stuff. And then, you know, your hair is, they have to cut all your hair short. Could you sue us?
I think in this condition, I think they cannot sue because suppose I'm the one who goes in and then like, it's my choice to go in no matter what the sign says.
Absolutely, right? Rule number 1, when you made the contract, you saw the sign. And rule number 2, the sign was easy to see in a reasonable place. But here's the problem. Why did you come into my salon?
Because of the promotion price of just 1 RMB.
And now, because that's true, that sign on the wall means nothing. You got an inducement. I gave you something to get you to come into my business. And therefore, my exclusion clause has lost its power. A lot of businesses, they don't know this. They don't realize that their exclusion clause loses power if they give people a discount. Now, what about number 3? You could have entered into a similar contract with someone else without having to accept a similar term. What if, Crystal, you come to my restaurant and at my restaurant it says, if you lose your bag, we're not responsible. Now you have a very, very expensive LV bag So you don't want to do that. So you go to another restaurant. You go to Harry's restaurant. And it says also, if you lose your bag, we're not responsible. So you leave. You go to Isaac's restaurant. It also says that. If you lose your bag, you go to 6 different restaurants and they all say that. Now, because they all say that, is that probably a reasonable thing to say?
Yeah, because all the restaurant has similar rules. So
Sure. However, if you go to my restaurant and it says, if the food makes you sick, that's not our fault. Other restaurants, nobody says that. Only I say that. Then, could you, Crystal, have entered into a similar contract with someone else without having to accept a similar term? Could you have gone into a restaurant and had a similar contract for dinner with someone else without having to accept my crazy exclusion clause?
Yes, I have a choice.
And therefore, my exclusion clause is probably not reasonable. If a business is the only one that says this, it's probably not reasonable. If all the businesses say it, it's probably reasonable. So these are reasons, these 6 things are reasons that a court might say this exclusion clause is not okay. Number 4, whether the customer knew or should have known of this term. And then we'd look at the customs, we'd look at the course of dealings. For example, let's say I do business with Harry. Okay, Harry, we do import and export. Now, we sell seafood, fish. I sell fish from China to you in England, okay? Harry, you with me?
Yeah.
Okay, so I export fish from China and you import it to England. Now, every time we do this, if the fish is more than 2 days late, I give you 50% off. Now, we've done this for a couple of years. This time I deliver the fish and it's 2 days late and I ask for all of the money. And there's something in the contract that says, it doesn't matter if the fish is late. It doesn't matter if the fish is 50 days late. It doesn't matter. I get all the money. Now that's an exclusion clause because I'm trying to take away my responsibility. Did you know, like in our prior dealings, what about the customs? What about in this fish market? What if the general custom for everybody is if it's more than 2 days late, you take 50% off, if that's the custom? And you and I have done that for years. Is my exclusion clause still reasonable? That you have to pay me full price?
I don't think so.
No, probably not. Because looking at the market, everybody knows in this market, everybody knows if it's more than 2 days late, you pay 50%. And Harry and I have done business that way for years. Who cares that it's in the contract? Who cares that Harry saw it when he signed the contract? Who cares that it was in a reasonable place? It's not reasonable. Not in this industry. So sometimes it doesn't matter that rule number 1 is okay and rule number 2 is okay. Now, let's talk about our case. Okay, so I want you to discuss a couple of these kind of examples. Give me examples like the ones I'm giving you. You know, discuss 2 or 3 of them. You don't have to give me all 6, but tell me some situations where an exclusion clause meets rule number 1 and meets rule number 2, but it's not reasonable. Like the kind of examples I just gave you. If you find this confusing, please send me a WeChat or let's have a call or something outside class. I can't spend too much time because I know this takes a lot of time. So in our case, one last thing, automatically invalid clause. I said, under this law, the Contract Terms Act 1977, there's one more thing. It is void. You can never say, I'm not responsible for death or injury if I'm careless. My example with Juan, where I was a doctor. It doesn't matter the situation, you can never do that. Never, ever, ever in any situation, you can never say, if I'm careless and you get hurt, it's not my fault. It's just malum in se, it's wrong. Of course it's my fault if I'm careless. Now, could I say, if I'm careless and you lose your bag? Maybe. But I could never say, if I'm careless and you get hurt, it's not my fault. Clear? So I know it's a lot of information, but you know, we have this video, you have the other videos about this that are online, you have the PPT, and I'm available. In our case, what do I want you to talk about? This, follow this order, exactly. What was the exclusion clause in our case, and where was it? Rule number 1, when was the contract made? What was the offer? What was the acceptance? Did this guy, the customer, see this exclusion clause when he made the contract? Rule number 2, was there reasonable notification? Then the limitations, even if the rules are met, was it reasonable? And then is it valid in our case? And I'll give you one hint. And here's the hint. In our case, the exclusion clause has 2 sentences. Analyze them separately. The exclusion clause in our case has 2 sentences. They are separate sentences. Hey, ping ping, overslept again.
Hi, sir.
Okay, ping ping, if you just arrived, please do look at, you're gonna have to watch the beginning of this video because we're talking about task A, and it takes so much time to explain it all that I can't explain it all again in another class because next time we gotta go on to task D. But I recommend, now that was task A, I recommend that you guys go back and start at least writing the notes for it this week because task A is like its own thing. Are there any questions on task A right now before we go back to our torts lesson? No?
So the task A, just to recap, is about the limitation of exclusion, the rules.
Well, I mean, that's only part of it. Task A is about the exclusion clause. That's what it's about. What is it? Where was it? Did it meet rule number 1? You know, did this customer know about it when he ordered the food? Did it meet rule number 2? Was it in a reasonable place? Now, even though some of this seems obvious in the law, you still have to explain your logic nice and clearly. Just like in task B, you might have to explain, why does a cook have responsibility for people who are eating her food? I know you think it's obvious, but you can't just say, well, it's obvious. You can't say that. You have to explain why this person, I mean, that's a skill. Being able to explain simple things clearly is a skill. Okay, let's get back to talking about torts. We're definitely, I think, be able to finish part 1 today and get into part 2. What we were talking about before is damages. We already talked about the duty of care for tests, and we talked about the duty of care for tests, we talked about the breach for tests, and then we got into talking about damages. So let's pick up from where we were. Let's go back a couple of steps to make sure we're on the same page. So damages generally means money, right? And we said there has to be causation. Whatever I did to hurt you had to cause the damages. We call that causation. And I said causation has this idea of being like a chain. That one thing happens, and because of that, thing number 2 happens. And because of that, thing number 3 happens. And because of that, cause, right? Because. So I come to school late. And because I come to school late, you guys, let's see, because I come to school late, you guys leave and go outside to have a cigarette. And because you have a cigarette, you get in a fight. say Isaac and Junpyo get in a fight. And because they get in a fight, they push each other and Junpyo falls. And because Junpyo falls, Florian tries to help him up. And because Florian tries to help him up, Florian knocks over Tiffany's bike. And then Tiffany gets upset, so she pushes Florian. And then Florian falls down and breaks his arm, and then he went to the hospital. And because he went to the hospital, he had to take a taxi. And the taxi driver was really mean to him. And because the taxi driver had a bad day, and then the taxi driver was even more angry. So he went to a restaurant and he hit the cook. And because he hit the cook went home and yelled at his wife, and then the cook and his wife got divorced. And the cook and his wife sue me because I went to school late. Is there causation in this crazy story? Well, except for me going to school late, none of these events would have happened. So in that sense, yes, I'm part of the chain of causation. However, of course, I never could have foreseen that if I went to school late, any of these things would happen. So I'm not responsible for them. And we looked at a couple cases. Yes, Florian.
Sorry, sir. Last time I asked you, what is the limit for the but-for test? And you said if there is a direct correlation. So it's like one circle before or after the problem.
It's not about how many links in the chain. It's about foreseeability. That's really the question. Could I see if I was late, my students might go outside to wait for me? Maybe. I could see that. And could I see that if my students went outside, they might have a cigarette? Yes, I could see that. Could I see that if they had a cigarette, they might get into a fight? No, probably not. I'm not responsible for that. What if, let me change the example. You guys were waiting for me. You go outside, you have a cigarette, and Florian, you light the cigarette, you drop the match on the ground, and there was oil on the ground because yesterday, then oil company came and they were careless and they spilled oil on the ground. And now the match hits the oil goes up and a bunch of people get burned. Could I be responsible for that? Probably not. I could not see that there would be oil on the ground. You know, but like anything that I'm responsible for is something that I could see might happen. I'm just not responsible for anything I can't foresee. So we looked at some cases. We looked at this case of Chelsea Hospital where it didn't matter. This was a but-for test case where there was somebody who was very sick and the doctor gave a bad diagnosis, but it didn't matter because this man was going to die anyway. The doctor's diagnosis was not the reason that he died. The doctor was not part of the chain. Then we looked at, here's where we stopped. So, okay, let's start here. When I was 12 years old, I fell off my bike and I hurt my knee. So my parents take me to the hospital and the doctor makes a bad diagnosis. He says, my knee is fine, the pain will go away, don't worry about it. By age 20, my knee is paralyzed. So I sued the doctor for negligent diagnosis. And this is okay, even though it's 8 years later. In this case, the statute of limitations that we talked about, you only have like 5 years. That doesn't start until you find there's a problem. So that didn't start when I was 12 because I had no idea there was a problem then. It didn't start until I was probably 20 and I went to a doctor and they said, oh yeah, your knee is paralyzed. What happened? And I said, when I was 12, I fell off my bike. And the doctor said, well, if the diagnosis was made correctly when I was 12, there was still a 75% chance my knee would develop paralysis. Now, what do you think, Tiffany? There's still a 75% chance that even if the doctor was right, I would still be paralyzed. Is the doctor part of this chain?
I know the edit to this case, but I would just say that I will blame the doctor, and no, I don't think the doctor isn't in a chain. He is in a chain.
Okay, so you know the case, but you're correct. The doctor is not in the chain because what the court said is we need at least 51% probability. If it's less than 50%, then you're not really part of the chain. It has to be really that what you did caused the harm to happen. There has to be causation. Okay, so this is a causation case. Now let me tell you probably the most famous causation case. There's actually two very, very famous ones. We'll get to the next one in a little bit. So here's the first very famous causation case. So I get a job working at a construction site, and I have an illness where I have seizures. I have physical fits. It's called epilepsy, when I see flashing lights. You guys familiar with this disease? You know what I'm talking about?
Yes.
Okay, Junpyo, are you there?
Oh, yes, I am.
Okay, your camera's off. I don't like that.
Worry
Prefer your camera on. I want to see ya. I want it. Where are you? You're in a place you can't turn the camera on? All right, fine. Okay, so Aruni, I'll talk to you about this. Aruni, I have this disease, okay? Now, I work at this construction site, and I'm up on a high platform doing some work. I see some flashing lights, and Aruni, I have a seizure. You know what I mean? A seizure? I have a seizure. Obviously, I fall on the ground. I start kind of rolling around. Now, there's supposed to be guardrails. There are supposed to be guardrails, these rails on all the platforms. But the company that made the platform was careless. They were negligent, and they didn't put the rails on. I have a seizure. I fall down, and I fall down 4 stories, and I break my legs and back. I sue the construction company. They say it's not their fault. They didn't know I had this disease. I didn't tell them. What do you think?
I think
here's the question. What caused my harm?
himself because he had seizure.
So, but for having a seizure, he'd be okay.
Yeah. He wouldn't
If he didn't have a seizure, he'd be fine. That's true. That is true. What about this guardrails thing, though? If the guardrails were there, and that's like a full, complete fence all around the platform, if the guardrail was there and he had a seizure, would he be okay?
A guardrail, is it the pointy ones?
It is a solid fence. From the top to the bottom, no big spaces. He would not have fallen off.
Oh.
Now, what caused his accident? Except for there being no guardrails, he would be okay. Is that true?
He would still have seizure, but yeah.
But he wouldn't have fallen. And therefore, now in this case, he had an epileptic fit. He actually died. Okay, he fell down and died. And what the court said is, yeah. They said, you know, look, it's his epilepsy that killed him. And he said, no, it was the guardrails. And the court said, the damage would not have happened but for the defendant, the guardrail, the lack of guardrails. It would not have happened. He would not have fallen. If the guardrails had been in place, he would have survived. He would still have epilepsy, but he wouldn't have fallen. So we really need to think about this but-for chain. What caused the harm? Now, there's one more test we have for this, but let's look at one more chain case. Now, let's say that Let's say that I'm driving on the road. Okay, I'm driving on the road and Caitlin, you're playing in the street with your friends. You're having a street party. You're running around the street back and forth because you think that's fun. And I'm driving and I see you in the road and I'm like, oh my God, and I spin the wheel to avoid you and I don't hit you, you're fine. But I hit a tree and I die. Can you say that's my carelessness? What caused my death?
Well, us playing on the streets caused your death because we messed up your concentration.
Well, but what your lawyer said is that the cause of my death was me spinning the wheel. Here's my question, Caitlin. Did I make a conscious decision to spin the wheel?
Yes?
Did I think in that second when I saw you, oh, there is a girl in the street. What shall I do about it? Shall I hit that tree or shall I go to the right? I think I shall hit that tree. Let's make this happen. Okay. Is that what happened?
No, it's more like an instinct. Someone's in front of you, so you quickly move your car.
Right. And that does not, and here's a key word, it does not break the chain. So in your essay, you need to talk about this chain of causation, but there are things that might break the chain. So you have to show that there was a cause. Something caused the harm, and it was the breach of the duty of care caused the harm. But the chain sometimes gets broken. We call this novus actus interveniens. You definitely don't need that. But it's an intervening act, and you do need to know that in your essay. I want to know about intervening acts, and I'm telling you right now, there is at least one in your essay, intervening acts. I took out a really hard one to make it easier for you, but there's still one. So what's an intervening act? Well, let's look at an example of it first. I'm the captain of a boat, and I don't use a compass. Y'all know what compass is? I navigate by the stars. My boat crashes into another boat. Whose boat should I crash into? I'm going to crash into Ping Ping's boat. Ping Ping, are you there? Can you turn on your camera? Hi. So I'm going to crash into your boat. Now, so my boat was pretty big and your boat is smaller. And your boat, Ping Ping, is sinking. Now you are the captain and you have a lot of people on your boat. And if your boat sinks, they're going to die, maybe. So here's what you do. You lower the lifeboat, you get on the lifeboat with a few of your people, and you sail over to me to talk about what to do. But it's very big waves and the lifeboat overturns. Oh, I'm sorry. In this example, you die. So you die along with the people on your boat. And of course, your family sues me. And I say, look, I didn't kill Ping Ping. She got on a boat. She got on this lifeboat. That's what killed her. What do you think? Did I cause your harm or did you cause your harm? Here's really the question, Ping Ping. You understand my boat hit your boat, yes?
Yeah.
And you understand that your boat is going to sink.
Uh-huh.
And you need to deal with this now. Was it reasonable for you to get on a lifeboat to come over to my boat?
Yes.
Yes. Now, what if instead you jumped off of your boat into the terribly big waves and tried to swim over to my boat? Would that be reasonable?
No.
No. And if you did that, then you would be responsible. But a lifeboat is totally reasonable. And that's what the court said. I, the owner of the Oropesa, am responsible. The captain, Ping Ping, did not break the chain because what she did was reasonable. Unreasonable actions will break the chain. So if you decided to swim over, that's not reasonable, that's crazy. Now you're responsible for your own death. But doing reasonable things doesn't break the chain. Just like if there's a child in the street and I spin the wheel, that's reasonable. Of course I did that to avoid the child. I'm not responsible for doing that. That didn't break the chain. But anytime there's something unreasonable, that breaks the chain. So the example I just gave with the car is Carmarthenshire, which is the same things, that this is a driver's reflex action. And a reflex does not break the chain because it's totally reasonable. If you see a child in the street to spin the wheel, of course. Doing anything that's reasonable doesn't break the chain. So if I cause you harm, let's say that, Florian, you come to my restaurant, okay? And I serve you, you order the chicken soup. So I give you the chicken soup and you eat it and it's disgusting, okay? Now actually it is. I used all the wrong things. I put in salt, I put in sugar instead of salt, and I put in just it's bad, it's disgusting. And you like spit it out on the table because it's just so disgusting. That's reasonable. Like you didn't, that's reasonable. But let's say that you're so angry that the soup is bad that you take the bowl and you throw it at the wall and the bowl smashes and pieces of the pottery fly around the room and one of them hits Isaac and cuts his face.
Damn.
Can he sue me because I made this bad soup and that caused you? Why not?
You will sue me.
Why?
Because of the direct correlation between him being hurting and my act of, how do you say, savage, sorry.
Was your act reasonable?
No.
Therefore, he can't sue me. Right? He can't sue me because you broke the chain. Did I cause this chain to start? Yeah. I was negligent. Right? I made the soup bad. That's negligence. So what if, let's say you have an allergy. You're allergic to nuts. And you tell me, David, I cannot eat nuts. So I make this soup and I was careless and I put nuts in the soup. You take one bite and you start to get sick. Now, what if because you get sick, you're holding your throat and you go back and your chair falls over and it hits Isaac behind you and it cuts his head? Now, could he sue me?
Yeah.
Yes, because you falling backwards is totally reasonable. You didn't do anything unreasonable. The chain has not been broken. So we really need to know when someone starts doing something that's negligent, does something careless. Did that chain get broken? Now let's look at kind of a hard example. This is a sad story, I'm going to tell you that. So there's this family called the Mitchell family. And they let their 12-year-old son, Dimitri, stay with his friend's family for the 4th of July. And they stayed near a lake. Dimitri's friends knew that he couldn't swim. But they took him out to a deep part of the lake anyway, and he drowned. Okay, now the family knew that he couldn't swim, and they said to their sons, do not let Dimitri go in the water. He can't swim. Don't let him. But they're kids. They went to the lake anyway, and he drowned. The Mitchell family sues the friend's family for negligence because they had a duty of care to watch the young boys. Now, here's what I want to know. Were they negligent? Harry, tell me what you think. So you understand the story?
Yeah. So I think, yeah, they had a duty of care because they were looking after the kid. But,
absolutely. They did have a duty of care. Did they break their duty of care? Let's run through the tests real quick. Risk of harm. Is the risk of harm, is it very likely, high or low probability? Is it likely that kids who can't swim near a lake will drown?
Yeah.
High or low probability?
It's quite high.
Really? Do all kids near lakes drown?
Wow,
Is
there's
this a
a
giant
chance.
problem that every kid who's near a lake just jumps in and drowns?
Okay.
I don't think
Well,
it
there's a
happens
chance.
that much.
All right. Okay.
But the actual seriousness of the harm.
All right. Yeah.
If you have a kid in a lake who can't swim, he's going to die.
Yeah.
So the likelihood isn't that high, but the seriousness is super high.
Right. Yeah.
So risk of harm is pretty heavy on that side of the scale. Is there any social benefit to having a kid who can't swim go into a lake? Or is there any social benefit to having the parents not watch the kids? Social benefit for the whole society?
No, there's no social benefit.
None. What would it cost the family to watch the kids more closely? High or low cost?
Low cost.
Low cost. So on that one side of the scale is almost nothing, right? Super low cost, no social benefit. And on the other side, we have a pretty heavy risk of harm. And what about a reasonable, so already the scale is tipped. What about a reasonable family? Would a reasonable family not watch a 12-year-old near a lake?
I think so, because I think he's old enough to like play on his own. Like 12-year-olds go.
And the court said this is absolutely a discussion. Is a 12-year-old old enough to understand, don't go in that lake?
Yeah.
So that's a question. It's a maybe, but they did break their duty of care. Now, damages, but for. Is this sentence correct? But for, except for, the family not watching Demichi, he would, 100% would be alive today.
Yes, yeah.
Could they watch a 12-year-old boy 100% of the time?
No.
Yeah, you and I have both been 12-year-old boys. You know, parents cannot watch kids 100% of the time, not when you're 12.
No.
You know, he could have gone out in the middle of the night to this lake. We can't say 100%. But we can say that the family was a substantial factor in why he died. And so the court created our third test. We had but for test, we had foreseeable test, and now we have our third test, substantial factor. And what the court said is, you know what, sometimes it's not 100%, but it's more than 50%. And all we know is the defendant was a substantial cause. They kind of really did cause the harm to the plaintiff. It's not 100%, but it is causation. It's close enough. And so they created this new test called the substantial factor test. Now let's say that I take a boat ride. I'm going to take a boat ride with my good friend, Caitlin. Okay, Caitlin and I go for a boat ride. And the waves are really, really big, way bigger than we expected. Okay, and it's a little scary, honestly. Now, I fall off the boat. And I'm not a very good swimmer, but anyway, the waves are super big. I fall off the boat, and the people on the boat try to save me. They put down the lifeboat into the water and they search for me, but it's too late. And Caitlin, you sue the boat company and you say their lifeboats were too old. If they were newer, they could have lowered them down into the water faster and saved my life. Do you think that that is the cause of my death?
No.
What was the cause of my death?
Choppy weather?
Yeah, sure. Really big waves and terrible weather. Now, if their lifeboats were newer, is there a better chance they could have saved me? Sure. But is there a 75, 95% chance they definitely would have saved me? Is their failure to have brand new boats a substantial reason that I died?
No.
No. So in this case, this is called Ford versus Trident in 1919, and the facts are the same. And they said, the court said, listen, negligence has to be that if this party wasn't careless, if this person or this business wasn't careless, the damage wouldn't have happened. That has to be the rule. And so even if this boat company had the brand newest lifeboats, the accident would still have happened. I still would have fallen into the water. It wouldn't have definitely saved me. It would have improved my chances, but it wouldn't have definitely saved me. So they said, no, that is negligence. Here's a word you might not know, intestate. Intestate is any person who dies without a will. Tell me somebody, what's a will?
It's like the documentation that you fill out, and it sort of tells, like, when a person passes away, it gives information of who their assets should go to.
Sure. So it's something that you write that says, when I die, my stuff goes to who, right? I give my house to my sister, I give my car to my best friend, I give my sneaker collection to my cousin, whatever. That's your will. If you don't have one, when you die, we call you an intestate. An intestate is a person who dies without a will. If you die without a will, who gets your stuff?
Our family?
It depends on the city, the state, the country. So typically, yes, you're right, your family will get it. But like in some places, 100% of it would go to your wife or your husband. In other places, it would be split between your spouse and your children. In other places, it would go to your parents. So there are different rules about who it goes to. In New York, it goes to your wife or husband with the expectation that they will give it to your children, but it doesn't go directly to your kids. Let's see. We started at 8. Okay, we can take a break now. Let's do one more case, and then that gets us to a little stopping point, and then we'll take a break. Okay, and then we're almost done with this part, which is great. I would like to keep you guys here 3 hours. I think we need that for torts. Okay, one more case. I work at a cleaning company, and each day I use chemicals to clean the bathrooms in office buildings. After work, I ride my bicycle home. Recently, I've developed a serious rash on my arms. So I went to the doctor, and he said that the cleaning products are harming my skin, but of course the harm is much worse because I'm getting sweaty on this ride home. And I sued the cleaning company for my injuries, but they say it's my fault for riding my bike home. Jody, what caused my injuries? Jody, let me ask you another, let me ask you this way. I agree, but let me ask you this way. But for me riding my bike home, I'd be fine. Is that true?
Yes.
So then the problem is riding my bike?
Oh, sorry. I mean, no.
Right. Except for me riding my bike home, I'd still have this problem on my skin. It wouldn't be as bad, but I'd still have the problem. However, if I said, but for these chemicals, I'd be fine, that's true. So therefore, it's the chemicals causing the problem. Okay? The court said the defendants are liable. The breach contributed or materially contributed to the injury. It doesn't matter if there are other factors, it's which one is biggest. Okay, cool. Let's take a 10-minute break, and we'll come back at around 56 past in 10 minutes. Okay, we are recording again. And now we are ready to almost finish torts 1, which I know you're all very excited about. We're right on schedule, so that's good. And we were just talking about a lot about the but-for test. Let's talk a little about the foreseeability. And remember, this is different than duty of care. When we talk about foreseeability of duty of care, we're talking about responsibility. And I can't stress that enough. You know, when we talk about duty of care, let's repeat that again. Make sure we got that. Caitlin, maybe you're not there. Crystal, when we talk about duty of care and foreseeability, what does that mean?
Duty of care, you look at responsibility, but the damages, you look at the time of the harm that you can foresee.
Okay. And Junpyo, is in duty of care, is foreseeability subjective or objective?
It's subjective.
What does that mean?
So it's related to the one who's related.
Sorry, louder, please. I can't hear you.
He's like, it's related to the one who's in the painting.
I can't really hear you. It's very quiet.
So, it's related to the one who's in the chain.
It's related. No, chain is damages. Duty of care has nothing to do with the chain. That's damages. Juan. Okay, Junpyo, say again.
Something you're responsible to?
Yes, that's duty of care is about responsible. And foreseeability is subjective. So I want to know what that means. Juan, can you tell me what that means? Foreseeability is subjective.
Like when it's, I don't know, like only for you, like.
What about for you?
I don't know how to explain it. I don't know how to explain it. Well, subjective when it's like your own ideal, like.
Of what?
I don't know.
Okay, Aruni, can you help us with this? Foreseeability for duty of care. How can you explain that? It is subjective. What does that mean?
It's like personal responsibility.
Okay, sure. I'll accept that. Can you see you have a responsibility? It's personal. Does a person think they personally have a responsibility? Those are two good keywords to remember. Personal responsibility. Objective is society's opinion. That's duty of care. When we talk about damages, we're talking about something else. We're talking about consequences. If I hit you, and I said this last week, if I hit you in the arm, I expect your arm will hurt. I expect that consequence. If I serve soup to Harry and the soup is very bad, I expect him to not eat the soup or maybe spit out the soup. I expect that. That's the consequence I expect. Now, it doesn't have to be exactly the precise way. You know, it doesn't have to be exactly what I expected would happen, but it has to be something I could foresee would happen. And I don't have to see the extent. And I said that last week. So let's look at the most famous case. And I expect you to use, there are two cases I'm going to show you now. Both of them I expect you to use in your essay, in your midterm. Number one is about expectations. So I own a dock where we allow boats and ships to anchor. Okay? Now, of course, our dock is made of wood, as boat docks are. And one of the ships that's here is doing some welding work on the hull. Now, if, you know, welding, obviously you're using fire to melt the metal. An oil company was delivering oil to a different ship 600 feet away, and they spilled all of their oil into the harbor. However, this was special oil. This was called furnace oil. Furnace oil, when it touches water, does not burn. That's what, and we brought in a bunch of experts and they all said, don't worry. Furnace oil, when it touches water, does not burn. So just to be safe, we stopped the welding project until we felt the oil was cleared, and then we started again. However, there was cotton, a big amount of cotton that was floating in the water, and the oil had gotten into the cotton. And they were doing welding and it hit the cotton. And that caught on fire, and then there was lots and lots of damage to our dock. So we want to sue the oil company because they spilled the oil. But they say there's no way they could have seen that there would be a fire. And we say, but for them spilling the oil, there would be no damage. Is that true? Nicola, but for them spilling the oil, there would be no damage.
Yes, this is true.
That's true. But could you also say, but for them buying a boat, there would be no oil to spill, there would be no damage?
That's also true.
That's also true. And but for the bank giving them money to buy the boat, there would be no boat, and there would be no oil spill, and there would be no, and but for somebody opening that bank, there would be no loan to buy no boat, to spill no oil. So the problem with the chain is we can kind of go forever. And if we're going to blame the people who bought the boat, we can just blame the people who opened the bank, or their parents, or their parents' parents, or whatever. So the but-for test doesn't really work well enough. We need another test. And here's the question. Could this oil company have seen that this oil would catch on fire on the water? And the answer is no. This kind of, and this is called the wagon mound. I said I expect you to use this in your midterm. It's a hard case to understand a little bit, but I want you to use it. So the point of this case, and the facts are the same that I said, the defendants did not know and could not have been expected to know that this oil could catch on fire. Were they negligent in spilling the oil? Sure, absolutely. And if you sued them for pollution, you would have won the case. If I sued them for spilling the oil and said it made the dock dirty, I would have won the case because it did make the dock dirty and they were careless. But I sued them for lighting the dock on fire, for the fire damage, and they could not have seen that this type of damage would happen. Is that clear? Okay, one more case that I want you to use in your midterm that also goes to this idea of consequences or expectations. So there's a man, and he's running in the street to catch a bus. He has a bag in his hands, and the bag falls, and some bird food spills out. Some birds come and eat it, and then that causes a car to turn quickly. The car hits a bicycle, the bicycle hits a dog, the dog runs away and bites the girl. Ping, ping. Is the man liable to the young girl for her bite? No ping, ping? Where'd you go? How about Floyd? Ping, ping, Floyd, Isaac. Where are you guys?
Yes, sir.
Sorry, sir.
Okay, Floyd. Were you paying attention?
No, I went to the bathroom and I just came back. Sorry.
Okay, that's too much information. Tiffany, tell me, is the man liable to the young girl?
That's an intervening circumstance.
Okay, can you tell us what does that mean, intervening circumstance or intervening act?
Well, the chain of causation isn't directly involved. It's just happening parallel.
Okay, so the key word there would be, did this break the chain? That's what we want to know. There's definitely a chain here, right? I mean, there is a chain that this man is running in the street. Okay, this man is running in the street. And because he's running in the street, this bag falls. And because the bag falls, the food spills out. And because the food spills out, the birds eat it. And because the birds eat it, a car turns quickly. And because the car turns quickly, it hits a bicycle. And because it hits the bicycle, it hits a dog, right? I mean, this is a chain, and it does start with the man running in the street. But the question is, at the end of this chain, when the dog bites a girl, could the man see, if I run in the street, because running in the street is careless, could he see if I do this thing, a girl will get bit by a dog? Could he see that? No, he couldn't see that. And therefore, he's not responsible for that. Now, is there anything here that breaks the chain? Not really. It's just not a foreseeable chain. What would break the chain? Let's say, for example, the man driving the car was drunk. Would that break the chain, Caitlin? Why?
It would break the chain because if he's drunk, it makes him more, it just proves that it's his fault for hitting the bike.
Why
because
is it his fault?
Maybe he wouldn't have hit the bike.
Okay, so he also was careless. So it's a new carelessness. What if, Caitlin, it's my dog, and I know my dog bites people, but I keep him in a cage, and today I didn't bother to lock the cage, I forgot.
Oh, then it's your carelessness.
So that would break the chain too. And then if the girl wants to sue someone, she could sue me for letting out my dog, she could sue the man for being drunk, and she could sue this guy for running in the street. And the guy who's running in the street, it's not foreseeable. He's probably out of it. So in this case, what happened in this case called Paul's graph, and Paul's graph is a very important case, and I recommend you watch a YouTube video about it. I don't think we need to do it together as a class, but I recommend you watch a YouTube video about it to make sure you understand. So there's this woman named Helen Palsgraf, and she's waiting for a train at a train station. Across the tracks, there's a man who was running to catch a train, and he's carrying a bag. And as he's running, his train is leaving. So the railroad guards helped him. One of the guards was on the train, and they reached out their hand and said, "Grab my hand," and they pulled him onto the train. And behind him, another guard pushed him onto the train. So that's a little crazy, but they were doing that. I mean, this is 1928. But when that was happening, he dropped his bag, and in the bag were fireworks. The fireworks hit the track, and the track has electricity, and they exploded. And one of them was a rocket, and it went up in the air, and across the train station, it hit some scale, some very heavy metal scale, and it fell on Mrs. Palsgraf's head. So she sued the railroad station, and she said these railroad guards were negligent. Now, what do you think? Were these railroad guards negligent, Crystal? You had a guard who reached his hand out to a man running on the train tracks to pull him onto a moving train. Is that careless?
I would say yes if the guy have fell down because he grabbed him, but I don't think.
Do you think it's reasonable if you were hiring railroad guards? Would you tell them it's reasonable to pull someone off of the track onto a moving train?
No, it's not.
No, it's not reasonable behavior for a guard to do that. So they were definitely careless. Okay, guards should not do things like that. So they were careless. But could they see that if they did this and pulled a man onto the train, that woman way over there on the other side of the tracks would get hurt?
No, cannot.
No. And therefore, they are not responsible for that harm. Even though they are part of this chain, they couldn't have seen that. So at the trial court, they said, yes, the railroad guards were responsible. They appealed, and the appellate court said, yes, the railroad guards are responsible. Then they went up to the Supreme Court, and the Supreme Court said, complaint dismissed. They're not responsible. And they gave us this test called the zone of danger test. And the zone of danger says that there's this area around all of us that we can see someone might get hurt. If we're running, so I can see this area around me. If I'm, throwing rocks, I can see this area around me. If I'm riding my bicycle, if I'm pulling someone onto a train, whatever I'm doing, there's this area around me where someone might get hurt. But if you're out of that area, there's no way I could have known you'd get hurt. So you don't need to understand all of this legal language. But the point is, you have to show that the possibility of danger to you was very clear and apparent. Even though, of course, the harm was unintended. Negligence is not on purpose. Negligence is carelessness. It's an accident. So the guards did not intend to hurt anybody. I did not intend to make bad soup. You did not intend to hit me with your bicycle. There's no intention in negligence. This is an accident. But is the possibility of danger high? If I made bad soup, of course you could get hurt if you have an allergy and I knew that and you eat it. If you're riding your bicycle on the street, I could get hurt if you hit me. But we had a case in the past, if you remember, where a man was riding a motorcycle and he hit a truck, and a woman saw this and she lost her baby. She had a miscarriage and she lost her pregnancy. Was that man responsible for her loss of her baby? Who remembers this case? Florian, you remember that case? No? Anybody remember? You're muted.
Yes.
Yeah. It wasn't foreseeable because she was shocked, but he didn't know by doing the accident that she will lose her baby by seeing it.
Right. So his duty of care wasn't even foreseeable. And certainly her harm wasn't foreseeable at all. He never in a million years would have said, if I drive my motorcycle fast, some strange woman is going to lose her baby. He never would have thought that would happen. He might have thought, if I drive my motorcycle fast, I'm going to hit someone. He might have thought that. But you're only responsible for the harm you can expect.
David, in that case, the lady could sue the guy with the fireworks because it's quite dangerous, isn't it? It's like, I don't know, if you go out the street with a bomb in your luggage, this is like an explosive thing.
Well, it was a different time. It was 1928. So carrying fireworks wasn't seen like that. And that's true. But here's the thing. She didn't sue him. She sued the railroad guards.
So the railroad, I see.
And they could not have foreseen this harm. If she had sued him, maybe she would have won. Why didn't she sue him? Somebody tell me the logic.
Because the railroad have more money?
Yes, thank you. She sued the railroad because the railroad has money. And this guy who's trying to run, who can't even make it to a train on time, he does not. That's why she sued the railroad. But bad mistake. So we understand that when we have a chain, sometimes this chain gets broken. Some sort of other carelessness, like someone was drunk, or I forgot to lock up my dog. Something happens that breaks this chain. So we always want to know, this thing that broke the chain, was it foreseeable? So again, we have this word foreseeable. Was this intervening act foreseeable? Now let's say that I get in a fight Who should I get in a fight with? I'm going to get in a fight with Ploy. Ploy, are you there? Going to get in a fight? No, you're not there? Okay, Jody. I'll get in a fight with Jody. Okay, Jody, I get in a fight with you. And you hit me really hard in the face. And it hurts my nose. So I go to the hospital. And at the hospital, the doctor is drunk. And the doctor makes a mistake and gives me the wrong medicine, and I get really, really sick. And I sue you, Jody, because you're the one who hit me. If you didn't hit me, I wouldn't be in the hospital. Can I sue you for all of my damages?
I don't know, maybe it's like partly like you can sue me and also the doctor.
So why can't I sue you for everything?
Because I just hit you like maybe, for example, like 5 out of 10. But why it makes it 10 out of 10? Because of the 5 it was from the doctor, not from me.
Okay, so part of my harm was caused by the doctor, not by you.
Yes.
Here's the key question, Jody. Could you foresee, could you expect that the doctor would be drunk?
No.
No, and therefore you're not responsible for that. That's it. You know, it's about, can you expect that this intervening thing would happen? So here's an example. There's a gas truck that spilled gas on the street. And you have 2 people, Mr. D and Mr. W. So Ping Ping, I'll ask you. Okay, Ping Ping, Mr. D. There are these 2 guys on the street. And this gas truck spills gas. And Mr. D sees that Mr. W is standing on the gas. So Mr. D lights a match and he lights a cigarette. Now, we don't know if he did this on purpose or not, but he drops the match onto the oil. The oil the gas goes up in flames and Mr. W gets burned. So Mr. W sues the gas company. Will he win? Let's talk about damages. What caused Mr. W's harm? Mr. W got burned. What caused him to get burned?
Fire? Mr. D lighting the match?
Okay, but if Mr. D lit the match and there was no gas, would Mr. W be burned?
No.
But if there was gas and no match, would Mr. W be burned?
No.
No. So we have a problem here. The match wouldn't hurt him alone, and the gas wouldn't hurt him alone. Was the gas company or the gas truck careless?
Yeah, but I don't think like that's the big deal. Like,
Yeah, maybe not. But they spilled gas, right?
Like careless.
Well, but my first question, is the gas truck careless?
Yeah.
Yes, they spilled gas. So that was a big link. Maybe that was our first, where's my highlighter here? Our first big link in the chain is the gas truck spilled gas, right? They were careless. Now, the next thing that happened was Mr. D lit a match, and then Mr. W got burned. Here's the question. Mr. D lit a match. Does that break the chain? If that breaks the chain, then Mr. D is responsible, not the gas company. And here's the question. Remember, the question is about, was the intervening act, and here's the key word, foreseeable? Ping Ping, could a gas company see that someone might on the street light a match?
No.
Really, Ping Ping? When's the last time you walked around the street? Maybe it's been a while. But you know, when you're walking around the street in China, do you see fire?
Do I see fire? You mean like lighter? Like
Yes.
Yeah.
Do you see that a lot or a little? Is that incredibly rare or is it pretty common?
A lot.
You see it a lot. You see cigarettes being thrown on the street. You see lighters. You see that stuff all the time, right?
Mm.
So would a gas company reasonably foresee that somebody might throw a cigarette on a street?
Oh, yes.
Yeah, it's kind of foreseeable. I mean, not that it definitely would happen, but it's the kind of thing that happens. It happens all the time. It happens everywhere.
Mm.
Throwing a cigarette on the street isn't like a doctor getting drunk. I mean, cigarettes getting thrown on the street happens constantly. And because of that, this intervening act was foreseeable, right? Throwing the match on the street. So if we found that Mr. D, his name was Doer, if we found that Mr. D lit the match on purpose, then he's responsible. Then the gas company's not responsible. But because we don't know if Mr. D did it on purpose, then defendant is responsible. Because the gas company should have seen that somebody might throw a cigarette on the ground. And if you have gas there, there might be an explosion. So what we want to know about an intervening act is, was it something that could have been expected? Is that clear? Any questions? Okay, good. Let's move on. Making good time. Okay, so do check your midterm. Find out what was that intervening act, or was there an intervening act? Remember to take a look at that so you can ask me in class or you can send me over the quiz. But the key word is, was it foreseeable? Okay, let's move on to the second part of torts. A good 30 minutes, we can get going on this. There's another rule you need to know. And by the way, we can talk about the midterm for a second. Let's even talk about it for a second. Let's see if there were any intervening acts. Actually, wait, let's do a little more of this and then let's talk about it. There are two more things I'd like to show you, and then we'll talk about it in the last maybe 15 minutes. So the eggshell skull. Eggshell skull is a rule, and here's the rule. There are two ways to say this. One, what happened here? One, you could say you must take people as you find them. Another way to say it is you're liable for unintended damages. Now, the example I had given, I think, in a previous class is, let's say I get into a fight. I get into a fight with Junpyo. And Junpyo, you hit me in the mouth and I'm bleeding. Now, Junpyo, did you expect that if you hit me in the mouth, my teeth would hurt? Could you expect that?
Expect it.
Sure. And you expect that if you hit me in the mouth, maybe I might, maybe I'd cut my lip and I'd be bleeding. You expect that, right?
Sure.
Sure. But what if I have a disease and once I start bleeding, I can't stop and then I die? Did you expect me to die?
No, I didn't.
No. But why did I die?
Because I have punched you.
Speak louder, please. Because why?
Because I have punched you.
Yes. I died because you punched me in the lip. Did you intend to cause this much damage to me? No, definitely not. You didn't intend to do that. But you have to take me the way you find me. You can never say, I didn't expect he would be hurt so badly. You can say, I didn't expect he would have that kind of harm. But Junpyo did expect this. He did expect that my lip would be bleeding. He expected that. He just didn't expect it would hurt so much. And you can never say, I didn't know it would hurt so much. You can say, I had no idea that kind of hurt would happen. You know, what if, Junpyo, you hit me in the mouth, okay? And I go to the hospital and it hurts my, I go to the hospital and I call my mother and I say, Mom, I'm in the hospital. And my mom says, oh my God, no. And she slams down the phone and she grabs her keys and jumps into the car and she starts driving, but she's having a panic attack and she starts breathing very heavy. And then she hits a fire truck. And because she hits the fire truck, they have to stop. And then they can't get to someone's house. And the house goes up on fire. And in that house, there was a dog and the dog died. Can the owners of the dog sue you, Junpyo, because you hit me in the mouth?
I don't think so.
Why not?
Because I didn't expect that one.
Sure. You could not expect that to happen. Is it part of this chain? Yeah, sure, it's part of this chain, right? I mean, this chain started when you hit me. And then because you hit me, this happened. And because this, and because this, and because this, and because, sure, it's part of this chain. But you never could have expected that that would happen. And therefore, you couldn't foresee it. So you're not responsible for that. But with you hitting me in the mouth, you just didn't know how bad this would be. And that's it. It doesn't matter. You're responsible for the extent. So I go to a bar, I'm having a drink. I get in a fight with some guy, and because of my punch, he loses his arm. Am I responsible for the lost arm? Junpyo, am I responsible?
Yes, you are.
Yes, I am. Right? And this is a famous case called Vosburgh v. Putney. And I think I mentioned this case before. You had an 11-year-old child kicked a 14-year-old child. And he had no idea that the 14-year-old's leg was very weak. The kick was really just a tap, but his leg got worse and worse. And finally, he lost the use of his leg. And they said, listen, you kicked him. Of course you didn't know this would happen. Of course you didn't expect this to happen or want this to happen. Doesn't matter, you kicked him. And this is called the eggshell skull. You take people as you find them. It doesn't matter that you didn't know. You want to protect yourself? Don't kick people. Don't hit people. Don't push people. Then you're safe. But if you want to kick someone or push someone, or you know, that's your choice. What if it's emotional? What if I am angry today and I say, Harry, I'm angry at you and I hate your shirt. I just hate your shirt, Harry, so much. I can't even see your shirt. What color is your shirt?
Blue.
I hate it. I hate your blue shirt so much. And so I get angry at you. Now, Harry, I had no idea that recently in your life, all these tragic things had happened. And right now you're very fragile. And the thing you love most in the world is this blue shirt that your grandfather gave you, and it's your family's most valuable possession. I didn't know any of that. And because I insulted your shirt, you get so upset that for days you just can't eat, you can't sleep, you miss a huge business opportunity. Can you sue me for that?
I think so, yeah, because you intend to hurt me. So the extent of that hurt doesn't matter.
It doesn't even matter that I intended to. Remember, negligence is carelessness.
Right, yeah, true.
It doesn't matter if I intended to. It just matters that I had a duty of care to you, and I broke my duty of care, and you got hurt. That's all that matters. It doesn't matter why I did it. Was it on purpose or not? Makes no difference. I had a duty of care. I broke my duty of care, and I hurt you. There's no way I could have known you would be this hurt, but it doesn't matter. I knew if I insulted you, you might feel bad. And you do. Much, much worse than I could have ever imagined. But it doesn't matter. That's eggshell skull. I have to take you as I find you. Just because I didn't expect the extent of your damages makes no difference. There's one more, pretty much one more thing we need to know before we talk about our midterm. And that is, it's not this, but how much is a leg worth is interesting. So you can go to this website if you want to know for every part of your body how much it's worth in different states. You can find out. Your parts of your body are, of course, worth different things. A leg in New York is worth $232,000. It's a lot of money for a leg, I guess. Your thumb is worth a lot more than your pinky. Different fingers have different prices. Your right hand and your left hand have different prices. You know, we put prices on everything. There's a price on human life. And one thing that's very scary is the amount of money that's given for a human life in different countries is very different. But interesting stuff. Kind of dark, but interesting. Ping Ping, you think that's a good price for a leg?
Yeah.
Okay. Great.
I think there was someone in the UK, there was like a case like this, I think a few years ago, where like a girl lost her leg. I think she got a lot of money for that. Like it was at a theme park in, I think, Thorpe Park. She was on a roller coaster and they got stuck on the ride, like I think her and her friend, and they were up there for hours. And then I think in the end she lost a leg. But
yeah, I mean, that can be suing them for a lot of punitive damages, a lot of punishment damages. Also, if there's a jury, the jury might award a lot more money. Yeah. In New York, they have maximum. You know, there's maximum, but not everywhere. Okay, that's not what I wanted to talk about. This is what I want to talk about. Sorry, yes, question?
I was going to ask if, for example, I was a cruiseman on a cruise ship in international waters, would it just apply to my country's laws for property damages?
Okay, I'm sorry, it's a little quiet. I couldn't hear you well. You're on a cruise ship in international waters. And?
Yes, and I'm employed.
Oh, okay, you're working on the cruise ship, okay.
Hello?
Yeah.
Yeah, and then I lose a leg. Yeah. Would it be my country's laws that apply?
If you're in international waters, I mean, it probably would be the country of the incorporation of the company.
Oh, okay, got it. All right.
So if it's a French company, it'd probably be French law. If it's an American company, it'd probably be American law. Especially if you're in international waters. Okay, last thing I want to talk about is the defenses to negligence. So if someone sues you for negligence, how can you defend yourself? And we have 4 ways. Number 1, illegality. So if you're doing something illegal and you get hurt, you can't sue for negligence. So let's say that I come up to Crystal and I have a knife. And I say, Crystal, I got a knife. I'm going to kill you. Give me all your money. And Crystal, you punch me in the face. Can I sue you for negligence because you hurt my nose?
No, because it's you are doing a wrongful act.
Okay. So if you're doing something illegal and you get hurt, you can't sue anybody because you chose to do something illegal. And remember, my example there was pretty obvious, pretty over the top, that I'm trying to rob someone with a knife. There are a lot of other things that are illegal. It is illegal to cross the street when the light is red. Now, if I cross the street when the light is red and Crystal is negligent and she goes through the red light because she is careless driving, can I sue her? Crystal, can I sue you?
I think based on this defense, you cannot.
Probably not, because I chose to do something illegal. Nobody made me. Nobody told me, David, do something illegal. I did it. And there were consequences. But what I did was illegal. Now, probably I would sue Crystal for number 4, contributory negligence. We'll get to that in a second. So illegality, if you're doing an illegal act and you get hurt, then you can't sue someone. What about consent? So Juan, I say, hey Juan, here's my bow and arrow. Do you want to play with it? But Juan, I'm telling you, it's very sharp and very dangerous. And Juan says, I don't care. I'm a man. I want to play with it. And you take my bow and arrow and you cut yourself. Can you sue me?
No, because I had consent. Like, yeah.
You agreed.
Like I agreed to take the risk, right?
Yeah, you agreed to take the risk. So we call this consent, or we call this, and you'll see this all the time if you go to like an exercise gym or a swimming pool, voluntary assumption of risk. This is what it's usually called in a contract. They're not going to have it in Latin, but it's volenti non fit injuria. So if you volunteer to do something, play with a bow and arrow, or go climb on a rock wall, you know, if you voluntarily assumed it, then you can't sue. If you go and climb a rock wall and you hurt your finger or something, you voluntarily assume to do that as long as the rock wall is safe. Now, this is often used in contracts to defeat an employee who's injured by not following a safety procedure. So let's say that at my company, which time do we have? Okay. At my company, we have some safety procedures. And if there's a fire, you are not supposed to use the elevator. Okay, whenever there's a fire drill, you can't use the elevator. You have to use the stairs. And today there was a fire drill and Ploy ran into the elevator. Now Ploy has worked here for a while. Ploy, you know the rules. You know that if there's a fire drill, you do not take the elevator, but she didn't care. She jumped into the elevator. And the elevator like fell down a little bit and you bumped your head. Can you sue the company?
No, we cannot.
No, because you voluntarily chose to not follow our safety procedures, right? You get this all the time if somebody didn't wear goggles or didn't properly clean their face or their body after using acid or using a cleaning solution. Then we have safety procedures. This is a big, big way that companies get out of paying people. Necessity. Now, let's say that I'm teaching class and I'm in class with you guys and Florian's ex-girlfriend runs into the room with a gun. And she says, Florian, if I can't have you, no one can. And she cocks the gun and she goes to shoot. And I say, no! And I run and I push Florian to the ground and I save your life. Now, but I pushed Florian to the ground and he hurt his arm. Florian, can you sue me? I'm a teacher. I can't push students, but I pushed you. Florian, can you sue me? Florian, can you hear me?
Yeah.
Did you hear my example?
What?
You did not hear my example? It was all about your ex-girlfriend trying to kill you.
Oh, yeah. Yeah, I do remember, yeah.
You remember? You're confusing me right now, Florian. I don't know what you remember. Aruni, can he sue me?
Yes.
Aruni, can he sue me?
No, sorry, no.
Aruni, answer this question.
No,
Why not?
because it says here that you can't sue someone for negligence
You can't sue for what?
if they acted to prevent a greater harm.
Okay. I prevented a greater harm. I saved his life. And if you prevent a greater harm from happening, you can't be sued. This, by the way, was the beginning of duty to rescue law. Okay, last one is contributory negligence. Contributory negligence says both people were responsible. And the court will decide how responsible each of them are. Now, I think we can pause there and let's talk for a minute about our midterm. So I'm not that concerned with us talking about the midterm. This isn't like a normal class where I give you an essay and you just go write it on your own. A lot of law is about how you explain things, how clear you are, and the cases that you find. So I have no problem with us talking about the case a little bit. So let's talk about this case again. Here it is. Ooh, that's not what I meant to do. Okay, so do you remember the story from your coursework? You have this guy named Bobby. He has this restaurant in Shanghai, and they have unhealthy food, right? You remember this? So here's the part of the story. Jack comes into the restaurant and he orders this crazy food that's so unhealthy. Jack had already consumed 5 cans of beer, and he was taking medicine for high blood pressure. Tell me about these. Somebody tell me about these. In terms of what we just learned today, what kind of things are we talking about here? Can any, yeah, Florian, can you tell me a little bit?
Foreseeability is like his health background check. Yeah.
So maybe there's some ideas of foreseeability. Any other thoughts?
Of foreseeability. Yeah.
Yeah. Thought I heard somebody else. Yeah.
Contributory negligence.
Okay, so there might be some contributory negligence. Was Jack in this situation, was Jack careless?
Because he knew he has a
Caitlin,
high
I see you nodding. What was careless about what he did?
That he already has high blood pressure. He drank a bunch of beer and then he goes into a restaurant, hasn't ordered anything, just leaves his bag and immediately goes to the bathroom.
But not even just that. What did he order?
The heart attack burger when he has like a blood pressure issue.
Yeah, well, he ordered the meal.
The meal, heart attack meal.
So we're talking about this terrible burger, all of this food, this shake with lots of caffeine. I mean, I'm not saying he was contributory negligent, but I think there's an argument there that maybe this was kind of careless behavior. Any other arguments?
You could talk about the exclusion clause.
Okay, so that's a separate thing, right? We can get into that in a minute. This is the exclusion clause. I just wanted to talk about this negligence stuff.
Can we say, like, I think it's the custom thing, like if he had this a bunch of times before and never have problems, can we say something about it?
Please, that's a good argument. That maybe this is a course of dealing. This is prior dealing. This is, maybe he comes to this restaurant every Wednesday and orders this and always has beer. I mean, we don't know.
I see. Okay.
You know, what we have to think about when you're writing this essay is you are not Jack's lawyer. You are not, what's the girl's name?
Ashley.
Ashley. You're not Jack's lawyer. You're not Ashley's lawyer. So who came to your office? It's Jack. Jack came to your office. He wants legal advice. And what we do in the law is we need to tell the person both sides. So Jack, here's what I think. If we go to court, here's what's going to happen. I think you can argue this, but I think Ashley's lawyer is going to say this.
Mhm.
I think her lawyer is going to say, look, you had 5 cans of beer. And yeah, you can say that you come here every week. But I'm just telling you what Ashley's lawyer is going to say. We want to be able to present both sides of this.
It's like
So-
a strategy.
Yeah,
Right.
sure. Well, we need to understand what are the 2 strategies here. So Jack can say, I went into this restaurant and I ordered this food. This part about the exclusion clause, let's hold for a second. Let's keep talking about this negligence. So he puts his bag down on the table. He goes to the bathroom. I think all that is about the exclusion clause. Now, what's going on in the kitchen? You have this person, Ashley. Now, all of this stuff about she worked at different restaurants, she's required, you haven't learned this yet. I'll tell you right now, all of this information about her, she has holidays, she has 5 days, she's worked for 3 years. This is all task D. We haven't done that yet. We'll do that next week. So all of this stuff about her being an employee and all that stuff, that's about can you sue the boss? That you need to know that info. But this stuff, Ashley was upset, for these reasons. She was not paying close attention. So here we're going to be talking about duty of care, breach, and damages. Jack takes a bite of the hamburger. All of these things happen. Now, Ashley was not paying close attention. What's the first thing? She puts a half teaspoon of pure caffeine powder. In my opinion, that is link number 1. That's the first thing that happened, really. Now, you might argue there's a link before then that Jack had 5 beers. Fine, maybe. But because she put this caffeine in the food, therefore, when he took a bite, what happened? Therefore, what happened? Therefore, what happened? Because there's other information, right? Which we'll learn next week, because this is all about damages. What kind of damages can Jack get? So this slide is really all about damages. This slide is really all about negligence. This slide is all about task D, which is called vicarious liability. Now let's talk a little about this slide, which is about what we just said, maybe contributory negligence. Some people might argue eggshell skull. Let's talk about this. So I said before, I want you to pay attention to the fact that this is 2 sentences. Sentence number 1 and sentence number 2 over here. Let's talk about the 2 rules we just learned today. Who can help me with these 2 rules? Who can help me? Anybody want to volunteer? So many volunteers. Okay, Florian will volunteer. Great. Okay, Florian, unmute.
Okay, for
Rule number 1. Okay,
for the
exclusion
first,
clauses. Rule number 1. What's rule number 1?
okay, for the So the notice have to be clear, and the information have to be mentioned before to sign the contract.
Okay, so rule number 1 is when you make the contract, that's offer and acceptance. At that moment, the customer had to know about this exclusion clause. That's rule number 1. So let's look at this clause. Where was it?
Behind the register, at the payment desk.
So when he bought his food, did he see it?
Yeah, indeed.
So rule number 1 is probably okay. What's rule number 2?
It has to be like on a logical place.
Good. And would you say the wall behind the register is a logical place?
Yeah, it was behind the counter, right? Like,
yeah. So probably rule number 1 is okay, rule number 2 is okay. Now, what about limitations? I said the key word is reasonableness. Look at the first sentence. The management hereby gives notice that no liability is accepted for loss of possessions. Harry, in your opinion, is that reasonable?
Yeah, I think so. That's
Why?
reasonable.
So as I said, you can never just say yes or no. You got to tell me why. Why do you think that's reasonable?
Because where the sign is and what it says, I think this particular notice is reasonable. Just for the
Yeah, but I got to know why. Yes, rule number 2 is okay. Rule number 1 is okay, and rule number 2 is okay. That's true. But now we're talking about the third rule, limitations. It must be reasonable. If this is reasonable, I need to know why. Nicola, can you tell me why?
I don't know if there's like a right or wrong answer for it, but I think it's not reasonable because if you go to a restaurant, they should care about your belongings.
I think that's a good argument.
It must be a safe place that you could at least leave your belongings in a table.
I think that's a good argument, but playing the other side, Harry, if you go into McDonald's, would you say that's a safe place to leave things?
No, I don't think so.
Probably not.
There's many other people in there.
There's a lot of other people. They certainly don't have waiters and waitresses. What kind of restaurant is this? Is this a super nice 5-star Michelin star restaurant serving a heart attack burger? Probably not. I mean, we don't know if it's really cheap or what. It might not be. It might be a nice restaurant. I think that's a very legitimate argument. Another argument, his jacket and his bag. Did he need to put those down? Let's say you walk into a restaurant. Let me choose a girl. Crystal. You walk into a restaurant with a very expensive jacket and bag. Very expensive. And you are about to go to the bathroom. Would you leave them at the table?
No. I
No.
will bring it.
You bring it. It's not that hard to bring a jacket and bag, right? It's not that big of a deal. He didn't need to leave it at the table. So maybe that's reasonable. Also, remember, we had those 6 examples. I think this is the kind of sign that you would see in any restaurant. I don't think you could find a lot of restaurants that say, we will take care of your bag if you leave it at your table. What about the second sentence, though? Tell me something about that, Tiffany.
Hi. It's just lagged. I couldn't hear the first part of the question.
Oh, my question is the second sentence. No liability is accepted for any injuries sustained through any services provided on these premises. Is that reasonable?
No, because they have a food license. The food safety is not part of that contract. That is not reasonable for a business.
Okay.
Like,
I think that's a reasonable answer. Anybody else have an answer? There's another thing we learned today that's also relevant there.
Because if it states like injury or death, it's actually void. You cannot.
Correct. So anytime an exclusion clause says, if you get hurt and we're careless, it's not our fault, that's automatically void. Now, Tiffany's argument about a food license, fantastic argument. I'll definitely give you points for that. That's thinking outside the box, and that's great. You know, but also this exclusion clause would be void anyway because of the Unfair Contract Terms Act 1977, which says you can never say, if I'm careless and you get hurt, it's not my fault. Of course it's my fault. So, like I said, I don't mind us going through this. You know, it's a lot of logical stuff. You know, I want to see how you write this. I don't need this to be so long. This doesn't need to be 20 pages. It just needs to be super clear. So get started writing it, see how it feels, look for cases, put in a little bit of time, at least one day, so you can feel, is this driving you crazy? Do you get it? Is it going to be easy? You know, put a little time in. Okay, any questions? No? Good? Okay, thank you for giving me the 3 hours, and I will see you guys next week. Let me give hosting control. Who should I give it to? Anybody want it? All right, Jody, you get it.
Sorry, David, just reminding, next week is a holiday, right? Do we have class?
Oh, is it? Next week is the 4th. You're
okay.
right. It's a holiday, so we don't have class. We could secretly have class and not tell anybody.
Please, no.
What if we have a secret class and someone, you know, passed away during the class? It would be our responsibility.
Exactly.
Are you sure?
Okay, that's a legitimate point. I don't want anybody to die during our secret class, so fine. No class, but then I expect some work on this essay, seriously. Email me if you have questions. I'm not going anywhere. There's a pandemic where I live. I can't even leave. So just email me if you have questions. Okay, I'll see you guys later. Bye.